the subcommittee, or the 6th meeting of the subcommittee on import, or the 7th meeting rather, 7th meeting of the subcommittee on import and export general amendment regulation 2013 is now called to order. Shall we invite the administration in, please?
早晨啊，秘書長。早晨。今日出席嘅當局食物及衞。
With us for today's discussion are Mrs. Marion Lai, Permanent Secretary for Food and Health, Mr. Philip Chan, Deputy Secretary, Mr. Brian Low, Deputy Director General of Trade and Industry Department, Mr. Thomas Lin, Head of Land Boundary Command, Customs and Excise, Mr. Peter Zi, Senior Government Counsel, DOJ, Mr. Gilbert Mo, Deputy Law Draftsman, DOJ, and also Dr. Ho Yuk Yin, Consultant, Community Medicine, Risk Assessment and Communications Center for Food Safety, FEHD. There are two papers for today. One is an administration's response to issues raised by members. The other one is the definition of powder formula. There are words added, like if applicable. We are going to visit this definition again when we come to the course-by-course scrutiny of the regulations. And some have been taken out of our consideration. We'll deal with these when we come to the course-by-course scrutiny. So, administration, will you take us through the outstanding issues? Right, let's maximize the time available. Let's aim to deal with the course-by-course as well. Mr. Chen. At the meeting on the 28th of March, members expressed concerns over two things. The first one is the definition of the powdered formula, whether it would include formula for adults as well as babies or children under the age of 36 months. Some would like to see clarification on this particular definition. I must point out that the definition is intended to cover the formula powder and soy milk powder for children under the age of 36 months. We aim to make sure that there will be stable supply of these products. When we consider the definition, we did consider whether the definition could be tightened up to such an extent that to say that it would be for those between 0 and 36 months. Apparently, this would address the concerns that there are certain products that are for people under and above 36 months. But if we narrow it down so much, there would be a glaring loophole. Because as long as the manufacturer states in the label that it is for people between 0 and 37 months, then they would be able to circumvent the regulation. This is our prime consideration. In fact, in the market out there, if we adopt the definition of 0 to 36 months, in the market out there are no less than 80 brands that would fall outside the ambit of the regulations, because the target customers would be for those above 6 months, above 9 months, about 10 months, about 12 months, or 1 to 7 months, and 1 to 7, and so on. And we would like to plug the loophole, and we would like to have regard to the separation of the different target groups. and therefore we cannot adopt this 0 to 36 months in the definition. In order to reflect our legislative intent, we say that persons of any age under 36 months, notwithstanding it is also claimed, if applicable, to be suitable for consumption by persons of any age over 36 months. In other words, they may say for instance, it's not applicable to those below 1, and anybody above the age of 1 year old will be suitable. But in fact, this may be suitable for children as well. And under these circumstances, they would fall within the definition. So when we drafted the definition, some members made the point that we have to specify the kind of products that we'd like to include. Now, for those products that meant for people over the age of 36 months, they will not be included, like those for elderly people above the age of 51 or for pregnant women. They will not be brought within the definition of this powdered formula. Other members expressed concerns that such being the case, since they are for adults and they're also for children under the age of 36 months. In fact, there are only 6 brands that are available. That's as far as we know. The manufacturers have already altered the labeling, or are in the process of altering the labeling. It's specified that they're meant for children under the age of 36 months. So as long as they make it clear that they would not be incorporated within the ambit of the regulations, I think that would address the situation in the market. I hope that would be of some help to members regarding the definition of powder formula. All right, questions? If not, let's move on to the clause by clause. Who's taking us through the clause by clause, please? Deputy Secretary. Chairman, let's stick to the Chinese version, if I may. The first one is the commencement date. It will go into effect on the first. It's gone into effect on the 1st of March. Let's start with number 5, and it would make it easier. Number 5, import and export regulation 60A, and after 8 we have added powdered formula, and this is included in the prohibited article, because in 6A, Schedule 2, the status will be a kind of prohibited article. When we have added the powder formula into Schedule 2, then under 60, import and export regulation 6B1, unless with the export license issued by the Director General of Trade and Industry, they are not supposed to export these prohibited articles. Otherwise, according to 63, a fine of $500,000 or 2-year imprisonment will be imposed. That's number 5, after adding the powdered formula. And then we move on to import and export general regulation 60A. We have included 3, 4, 5. Number 3, as you can see, there is a definition here. Now we have the latest version of the definition. We have made our policy clearer. There are a couple of points here. It is in powdered form, and we've also made it clear that it is for those below the age of 36 months, we have spelled out the powder formula and soy milk powder, and these are also for the nutritional needs. In number 3, we have added the definition. And number 4, we have added the self-use, the 60A, 61C. We have added the 61C. That's in relation to exemption. Now there are 2 conditions to be met. First of all, this has to be carried in his luggage. Within 24 hours, he is not supposed to have left Hong Kong, and also the weight is no more than 1.8 kilograms. Now, the idea is to make sure that if it is for self-use, then we allow them 1.8 kilograms, which is equivalent to about 2 tins in the market. Normally, it is 900 grams. Now, the 24-hour condition is targeted at the parallel traders. Now, with this self-use condition, will there be people who move in and out of the boundary crossing and abuse this condition? So we have this 24-hour condition. And in B, we have added this exemption, and within this exemption, under what circumstances will someone be able to avail himself of this self-use condition? Now, there may be circumstances in which someone within the past 24 hours has left Hong Kong more than once, and he was accompanied by someone under the age of 36 months. That the powder formula is not in a sealed container. Now, the baby may be cuddled, and at the point of exit, he is moving across the boundary, and the baby may need to consume this powdered formula, and there would be an exemption. Now, this he may be going in and out within 24 hours, and may be doing it more than once. And if we allow them a reasonable quantity, normally it is 24 hours, but in this scenario, there would be an exception. So that's all I have to say, Chairman. 1DB3, does it mean that if someone is carrying 2 tins, and these unopened tins, from time to time we may see some plastic boxes with different compartments, and each compartment will be good for one helping. Now they put it into the feeding bottle, and these kind of plastic boxes will be excluded, would they? And they will not be included as part of 1.8 kilograms. Right, in B, Chairman, they no longer fall within the 24-hour condition. In B1, it says that he may have left Hong Kong and then come back, and over the past 24 hours, he may have left Hong Kong. So this is an exception. He cannot enjoy the 2 tin exemption anymore. This is an exceptional situation. If it so happened that over the past 24 hours he left Hong Kong and he enjoyed the 2 tin exemption, but he was cuddling a child under 36 months at Lowell. Now, the powder formula has to be contained in a container in reasonable quantity. Let's say all these compartmentalized box. From the point he leaves Hong Kong, he has to consume the formula. As you know, babies have to consume the powder formula on a regular basis, say for breastfeeding. So we have these exceptional circumstances. Mr. Lo Wai Kwok. Chairman, thank you. 61D, Chairman. I do have some doubts about it. Now you have the 24-hour limit. Now he may have left Hong Kong. You don't have any record as to whether he carried the powder formula. Now, if someone is making crossing every single day into the mainland of China, yesterday he made a crossing at 10 a.m. without any powder formula, and this morning he made the crossing at 8, and within 12 hours he left Hong Kong. And if you ban or forbid him taking any powder formula, it would be too harsh. And they probably can't keep track of the duration. Now, how would you address this particular problem? Deputy Secretary, Chairman, Mr. Lo's scenario, this 24-hour requirement is intended to target the parallel traders who abuse the two-tin exemption. In fact, the Customs and Excise did pick up some parallel traders who are doing just that. Perhaps my colleague can add in just a moment. Now, Mr. Lo talked about the lifestyle, 10 o'clock, 8 o'clock, and so on. Now, he has to have time for rest, and for some reason he has to make the crossing at 8 o'clock and 10 o'clock and so on, but he has to have the rest time, like I said, in Sundays. Now, this two-tin requirement means that for babies between 0 to 6 months, they will consume a lot of powder formula. One tin would last 2 weeks, and 2 tins would last for 3 weeks, for example. As long as he can make the crossing on Saturday and Sunday, and he can carry 2 extra tins, that would be enough to last for the next 3 weeks. Well, before Mr. Lo follows up, I must say that we have to keep restrict to 5 minutes.
We should not consider the number of cans, because that person might not bring milk powder for a whole month. But let's say for once, his mother asked him to buy to get some milk powder today. And if it means that it's less than 24 hours between yesterday and today, it would cause a lot of convenience, and it might not be, the rule might not be understood by the general public. I understand the measure to counter parallel traders, but is this a reasonable measure? I hope you can tell me more about the thinking of and operation behind this measure. First of all, would the Customs and Excise Department check which people are suspicious and make inspections correspondingly? And if whether the customs will perform checks only if they have suspicion, would this be the case, or would you work with the immigration department and see if they the relevant persons brought any cans of milk powder within 24 hours. Thank you, Chairman. Let me talk a little bit about the 24-hour immigration arrangement. When we make inspections at the ports, and if we see any suspicious visitors, if the visitor brings more than 2 cans of milk powder, which are over 1.8 kilograms each, we would make inspections. And the way we carry this out would be to hand over the visitor's credentials to the immigration department, and the customs and immigration department has a link, and the immigration department would check whether that person had a record of leaving Hong Kong within the last 24 hours, and if so, we will that person will be a violation of the rule. And in our mechanism, we do not have a measure to verify whether the visitor had any previous experience of bringing milk powder out of Hong Kong. Any follow-ups from Mr. Low? So, in other words, if the person unfortunately violates the rule, I think this is not reasonable. I don't have a suggestion technically to solve the problem. I think the authorities should take notes. I understand Mr. Low's concern. Regarding multiple entries within 24 hours, and if the person get caught once, but he or she did not bring any milk powder in the past, this is not very reasonable. Thank you, Mr. Low's inquiry. The objective of our legislation is to counter parallel trading activities, and we need to strike a balance. So the visitors might have a need to feed their babies. And that's the reason we came up with the rule to set up a restriction of the amount of milk powder to bring within 24 hours. For anyone leaving Hong Kong together with an infant for a certain amount of time, for traveling or visiting relatives for a few weeks, he or she would have enough milk powder for the infants. And on the other hand, for parallel traders, we want to discourage them to regularly enter and leave Hong Kong. We need to strike a balance. And we understand this might cause some inconvenience to the general public, but we still need a method to execute. Any other questions? Thank you, Chairman. I have some questions for the administration. On page 7, the newly added number 9. Currently it applies to all places outside Hong Kong for powdered formula. I would like to know the basis for this policy. Right now, the problem is a lot of parallel traders bring large quantities of milk powder to the mainland. Would the measure actually affect a bigger scope than originally intended? If we look at page 7 or page 6, we have two ways to express it, and they both look very similar, and I'm not sure what's the difference. One said it applies to all countries, and for number item 1, 2, 3A, 2B, and 3C, they all have this scope, but for items 6, 7, and 8, it applies to places outside Hong Kong, and I want to know the difference. Can the government explain the difference? Director General, Chairman, for places outside of Hong Kong, by all means of transportation. I think that's the question by the legal advisor. It's not about the means of transportation. It's about where the milk powder is exported to. At the moment, parallel trading activities are through land transportation, but we would not rule out parallel traders bringing out the milk powder in other means in the supply chain. So if during the legislation, if we only limit land transportation, we are concerned that parallel traders might be able to overcome the limitation, and the legislation would lose power. I think the gist of the question by the councillor is something different. For the two items, one applies to all places outside Hong Kong, and the other is all countries. And these items are different, and they have different effects. Director General, Chairman, if we are talking about places outside Hong Kong, as the Director General pointed out, the parallel trading trade is ever changing. Some of them would bring the powder to Vietnam and importing it back, and the traders could use different routes. And in terms of the specific terms, I would invite our legal officer to explain further. I cannot explain why we used all countries, because the rule was set up a long time ago. And it applies to a lot of places outside Hong Kong, such as Taiwan, mainland, and Macau. I think this is a clearer way to define it. Was it set up a long time ago? I cannot speculate the use of other countries without referring to our archives. But for the purpose of this, for today, for the purpose of the legislation, I think having all places outside Hong Kong is the best solution.
Mr. Dennis Kwok, Chairman, I think of 1DB, the definition of powdered formula will include, or is likely to include those powder formula for those above the age of 36 months. Now, if someone is together with a baby who is 36, 37, 38 months, and it still has to consume powder formula, how would be have any bearing on them? Well, it means that if the parents are together with the baby over the age of 36 months, and they cannot carry any reasonable quantity of powder formula, is that right? Chairman, for a 3-year-old child, he can consume something else other than powder formula, according to doctor's advice. Well, my son is 3.5 years old, and he's still consuming powder formula. Well, Mr. Kwok, I think you are referring to those above 3 or 37 months. There are many children who would be consuming powder formula, and they wouldn't go to sleep until they've been fed powder formula. Mr. Kwok, of course, they eat adult food as well. Yes, when they cross the boundary, the parents would carry the powder formula with them. And would they be subject to any restriction? He may be carrying the powder formula, and the label on the tin specifies that it is meant for those under 36 months, and they will be subject to the regulation nonetheless. Is that what you try to clarify? Yes, thank you, Chairman. Let me try to answer this. 1DB is intended to facilitate those who are together with infants. We would like to meet the needs of those who are on the journey between one point to another. Now, if they are flying to the U.S. On a flight for more than 10 hours, that satisfies the need during this trip. Now, if you're moving from Lowood to the mainland, that is to satisfy the need for this short crossing. So we have to have an age threshold. Any age threshold would create a certain marginal group of people who might feel that they also have the need, and they doubt why the line has to be drawn like this, and that's quite inevitable. In our policy and in the regulation, we try to draw the line at 36 months. The reason being that for infants and babies, those below 36 months, and this is a clear cluster. When Mrs. Lai, this is not the focus of the question. Let me rephrase the question like this. I'm an old guy. I have to consume a glass of milk before going to bed, and then I carry some powder formula, and in the tin it specifies that it is meant for babies as well as for elderly, newborn as well as elderly. Would these kind of products be subject to the regulation? I don't talk about 36 or 30 whatever months. Well, Chairman, I think it comes back to the definition. The legislative intent is to target at powder formula below for babies below 36 months, and you have a broader definition. Now in B2, for those who are 37 months, they're still babies. They are, I mean, they are put in a very bad situation, and unnecessarily. Now for those below 36 months, they can carry with them a reasonable quantity, but once you've gone over that threshold, you will be prohibited. In B2, I'm wondering whether you should draw the line at 36 months. B2, should we draw the line at 36 months? Or should we tie in with the definition, the new definition that you have? Mrs. Lai. Well, I will address this after some discussion, but let me say this. For traveling need, it may be, 1B may be relevant. That they're leaving Hong Kong for the first time within the past 24 hours, and they can carry 1.8 kilograms. If you leave Hong Kong for the first time within the past 24 hours, now B, for the unsealed container, you're not leaving for Hong Kong for the first time within the past 24 hours. Well, you mull over this. Now, the scenario that I depicted to you may come to pass. Mr. Mo, well, overall in 1D, let me mention this in the context of Mr. Kwok's scenario. Let's say someone is leaving with a 36-month-old child. As long as there is someone above the age of 16, and they're leaving Hong Kong for the first time within the past 24 hours, and they can carry 1.8 kilograms. So it's only that everyone above the age of 16 who are leaving Hong Kong within the past 24 hours will have carried 1.8 kilograms that would be covered. Now, if they're carrying powder formula not meant for under 36 months, now let's say the powder formula is meant for 36 months or above, there would be no restriction on the quantity. They can carry as much as they like. Of course, 37-month-old children, they do have a lot of choices. Now, the situation depicted by Mr. Kwok is, number one, whether they have left Hong Kong within the past 24 hours, or whether they can carry any powder formula meant for people above the age of 37. That's the overall intention of this provision. Mr. Paul Chair. Chairman, the legal advisor's question about the definition of other countries, and that is a bit too broad. Now, we have been objecting to this, and that's precisely the reason that this import and export regulation, I think, and this is a bit too hasty. If you resort to this regulation for other products, they will be applicable to all over the world. We have all these treaties internationally, but here, for this particular issue, of course, this is of concern to me as much as to other members, but it is too destructive if a result to this import and export regulation. It's like screwing up, putting on a screw. We have to use a screwdriver, but this time instead of using a screwdriver, and you are hammering the screw in, and you're damaging the whole process. And you're making this applicable to all countries, and this is really what is bad about it. The Permanent Secretary kept emphasizing that the policy intention is to tackle the parallel trading. I think this is where we differ the most. Now, we haven't come to that stage where we have to resort to these means to tackle parallel trading, because once you've opened the floodgate, where are you going to draw the line? Parallel trading can be changing on a daily basis. If you enact the regulation to tackle parallel trading, there will be problems. We're not dealing with drugs. Drugs can be all-pervasive, and we can really make it very, very tight. But what we're dealing with today is not drug. It is a kind of commodity because it is in short supply. Something has to be done about it, but we don't necessarily have to use this context to tackle the problem. And this is also a kind of common sense. Hong Kong has always been a free society. We don't legislate unless it is a last resort. I think you have set a very, very bad example in the interest of expediency, in the interest of hasty decision. You are really grabbing any tool in your toolbox, and you are doing this by negative vetting, and this is really detrimental to Hong Kong's practice. Now, there are so many mums and kids who are adversely affected. Now, if you can do this, you can do the same thing with regard to human rights. You can grab anything in your toolbox and get on with it. Now, we pride ourselves on freedoms, on human rights, and there are some who wouldn't make any noises about it, but I must impress upon the administration this very point. I must emphasize that you have got off on a bad start. I think since you've got off on a bad start, you should not take such a big stride. You take a small step now, and at least you can come back. You can ditch the wrong ways. Now, the Permanent Secretary may not find this pleasing to her ear. Now, you have a more pressing issue after this one. You have the avian flu that you have to deal with. But this is an important issue that we have to contend with. I don't really want to be nagging the administration, but I'd like to put down a marker that you have really gone into a wrong direction. I think you have to come back to the right direction. I'm not sure whether you'd like to respond or not. Permanent Secretary? Thanks very much, Mr. Che. A moment ago, we talked about the policy intent. In fact, here on this platform, we have talked about this many times. Now, we have to tackle parallel trading, which has taken a lot of the powder formula out of the supply chain. And we have emphasized the importance of the baby powder formula for a particular cluster, 0 to 36 months. This is the sole source of nutrition for them. It is because of this importance that we propose this legislative amendment. Ms. N. Chung? Let me put a simple question, if I may. As a member of the public, someone may go to the supermarket for baby formula for presentation as a gift, and he can buy anything or even powder formula for the elderly. Now, how can he pick and choose? Now, he's buying a couple of tins. Let's say he's buying half a dozen tins. For a senior citizen, presumably that would not be restricted, right? Now, how can he pick and choose? Is it that as long as there is no labeling on the tin to say that it is meant for people under the age of 36 months, as long as this is not so labeled on the tin, there would be exemption. Now, this would make a lot of difference, because the senior citizens would like to pick up a couple of tins in the supermarket and send them as some kind of gifts for someone, and it would be very difficult for them to make the choices.
Yes, we can provide very clear information on which milk powder are not regulated, and I can provide some general guidelines. If on the can label contains instructions that it's intended for an age group of above 36 months. For example, some brands products are intended for people above 50 years old. These are most probably not regulated. For other brands, we have to look at the specific case. Some brands have a picture of a pregnant woman, and it's intended for breastfeeding women, and obviously these won't be regulated. Chairman, as all of you know, there are a lot of words, very small words on the cans. For older people, it's hard to read for them. Can we make the instructions clearer, or even can the Customs Department issue labels for the cans that they are regulated, to make it easier to identify for the public? So this would avoid any misunderstandings or mistakes by the local residents, and to avoid them from violating the rules by accident. This is a very special case. I have something to add. In general, for milk powder for babies, in most cases they have pictures apart from words, and they contain instructions for using the milk powder. The pictures would illustrate, for example, you should test the water temperature. They all have instructions. So if the elderly person wants to buy milk powder, they would generally know which brands to go for, and they would have these illustrations, these pictures, apart from words. And the pictures can help them understand. And usually these elderly people will consult the pharmacies. When the legislation is passed, I hope it's a convenience to the public. I think all exported milk powder should be labeled clearly. Next. Mr. Lau. In the last meeting, I requested the government to consult the milk powder manufacturers to see which products are suitable for babies from 3 to 12 months. Did you consult which manufacturers provide products for babies from 12 to 36 months? We have a good grasp of the products, the milk powder products out there, on which powder are suitable for babies from 12 to 36 months. Last time I requested the government to obtain these information from the manufacturers, that which products are adult formula and which ones are adult formula which are also suitable for infants from 12 to 36 months. Mr. Leung, did you read the document we sent out today? It did not mention which brands. This is not my question. For the new definition by the government, apart from the label on the can, it also covers other situations. And in case of disputes, the government would obtain more information from the manufacturers to see if the intent of the milk powder is is not covered in the label. The punishment is quite severe. It's a fine of up to 500,000 and 2 years of imprisonment. That's the reason I requested the government to consult the manufacturers to see which ones are for babies from 12 to 36 months. According to my professional knowledge, all milk powder are appropriate. So the legislation actually bans all milk powder. So we need to obtain this information from the government. Chairman, we addressed this question in this document. From my memory, the question last time was whether the powder formula covers all milk powder, and the question was about the scope. In number 8 in the document this time, some milk powder are for adults, but also suitable for other people. My question last time was very clear. I requested the government to consult the manufacturers to see which products are suitable for infants from 12 to 36 years old. That was my request to the government last time. In terms of disputes, according to my analysis, my understanding, all adult formula can be consumed by children from 12 to 36 years old. So the effect of this legislation is a comprehensive ban on all milk powder. I want to verify these facts, and that's why I requested the government to consult the manufacturers. If all adult formula are suitable for children from 12 to 36 months. I don't have the professional knowledge, but so have you thought about whether the adult formula products are well known to have been consumed by children? Let me respond. Now we are talking about the definition of powdered formula. Now the definition of powdered formula it's applicable to persons of 30 months old or lesser in powder form or other forms. There are a number of conditions. Mr. Leung's question last time was, are you covering all the milk powder? So we are making clear this time. We would not cover milk powder which are intended for persons over 36 months or over only. we are talking about, for example, powder for pregnant ladies or elderly people. If you ask the manufacturers if it's only intended for other people, you can ask if their powder are suitable for children. There is no milk powder only for pregnant women. Even if the milk powder states it's only for pregnant women, it can be consumed by children. Chairman, we are talking about the legislation. We have to make the legislation practicable, and we also have to serve very clear targets and clusters. And we have considered the legislative members' views. And according to our latest text, it mentioned the labels. It's intended or should be intended for children. We find 6 products in the market which fits the bill. We might have more, but this is an approximation. I have one question. In terms of the terminology, can be consumed and suitable for consumption, is there a difference between both terms? For example, a lot of some milk powder can be consumed by elderly people, but is it really suitable? We are talking about 2 different things. Chairman, if we look at the new definition of the powder formula, the point on suitability for consumption, for products intended for persons under 36 months of age. For children from 1 to 3 years old, they can consume the products from a medical point of view. But this might not be the original intent of the manufacturer. The gist of the legislation is not about the medical perspective, but whether we have to look at the intents, and the intents can be reflected from the product description on or label. Even if a product is suitable medically for people 1 to 3 years old, but this does not make it an intended product for that particular age group, because they are entitled to define the products as a product which is suitable for people over 36 months of age, and this would make it exempted from our regulations. Chairman, as we discuss more, I can see more loopholes, and I have a simple question for the government. Does the government know whether Model 1 is what each model of milk powder is intended for in terms of the age groups? Thank you, Chairman. The model of the milk powder, Model 1, Model 2, they do not have an international standard, and the manufacturers can define them using their own judgments. And for number 1, some of them applies to 0 to 6 months old, some of them from 0 to 9, or 0 to 12 months, and so on and so forth. Let me take this chance to answer the question. Please let him respond. Mr. Fang, my question was, what are the definitions of each model? Model 1, Model 2, Model 3, and so on. The answer is there's no international standard, and it differs from brand to brand. Some of them from 0 to 6 months, 0 to 12 months. There is no international standard, and each brand would have their own standards according to their marketing needs. And
Well, Chairman, numbers 1 to 4, they are for 0 to 36 months, but because of the labeling, because of the government requirements, those above 36 months, they have to specify that if you feed this to a baby below 1, it would not be advisable unless with a medical advice. So there is such a warning on a lot of the baby formula. Now, because of this formula, that this is 24 to 36 months, and it is meant for 2 and for 3, and for adult formula. I put a question last time, and the Permanent Secretary told me that this would fall within this definition. That the rice cereal has been taken out of the definition, but adult formula has been incorporated into the definition. Is my understanding correct, Deputy Secretary? Well, I think in today's paper we have made it clear that if a powdered formula is meant for adults, but at the same time it is also meant for 36 months old, this will fall within the definition. As we indicated in para 8, there are 6 such products in the market. There are some manufacturers that have altered the labeling or are in the process of doing so. They would specify that they're meant for those above the age of 36 months. And once this clarification has been made, they would fall outside the regulation. Mr. Fang, well, this regulation is coming all of a sudden. The suppliers have to create a new labeling in order to circumvent this. I don't think there are any powder formula that will specify 24 to 36 months. There is specification for those below 1. And the law will be drafted like this. Are you saying that the suppliers will have to create their own labeling? And like this is meant for those about 37 months, and that would fall outside the ambit of this regulation. Is that right? Permanent Secretary. Well, it is a commercial decision for the manufacturers, and of course they will have to ascertain whether the ingredients are suitable for the cluster that they're meant for. Now, for those that claim to have the products meant for those under 36 months, they would be included. Mr. Sin Chung Kai. Well, Chairman, you said something that is not consistent with Dr. Leung. Now, Dr. Leung said that for powder formula for babies above 12 months, there wouldn't be that much of a difference. Well, can you listen to me, Doctor? Powder formula meant for those below 1 and above 1, there will be difference. Some are labeled as adult formula, but powder formula for people above 1, there would be no difference. I think your interpretation of what Dr. Leung said is a bit different. Well, I didn't say that. I merely put the question, suitable or can be consumed. Well, what Dr. Leung said is that for powder formula meant for people above 1, there would not be any difference. I'm not sure whether the CFS, Center for Food Safety, is of the same opinion. And for the powder formula meant for people above the age of 1, there will be not that much of a difference. And your definition would cover all the powder formula meant for people above 12 months. Dr. Ho? Well, there is a big difference there, because there are different clusters, and they will change the ingredients of the formula. Now the question is whether powder formula for those above 1 would also be suitable for those below 1. Most are, except for certain formula. The definition here is not in relation to the ingredients. It has to do with the marketing strategy. If they claim that they are meant or suitable for consumption by persons of any age of below 36 months, they would fall within the ambit. Now, adult formula can be consumed by children, but if they don't have any claim that they're meant for those under 36 months, they will not fall within the definition. Mr. Sin, adult formula and also those meant for 36 months, what is the major difference between the two, Dr. Ho? There can be broad difference. They have the macronutrients and the micronutrients, the vitamin and nutritive substances. They cover a broad range. That there are dozens of organic substances in the formula, and the content can change. So depending on the age, the content of the formula can be changed to satisfy the needs. That's the reason why in the market there are products for pregnant women, for elderly, for those suffering from osteoporosis, and there are different types of formula for different segments of people. Mr. Sin, 24 to 36 months formula, they can be consumed by adults, but what about the scenario in which those below 1 consume these products? Well, we're not dealing with who consumes what. We're dealing with the marketing strategy. They're claiming, whether they're claiming that the products are meant for 36 months old or below or what. Conversely, for infant formula, adults can also consume, although they may not satisfy all the nutritional needs of an adult. But there are many adult formula that can also be consumable by babies, although they do not claim or make the claim that they are meant for babies under 36 months. Well, what any problem with adult formula being consumed by babies? Well, it all depends on the ingredients. Generally, for adult formula, a lot of them can be consumed by babies under 1. Dr. Lo Wai Kwok, we're dealing with the clause-by-clause, Chairman, but there are still administrative issues that remain outstanding, and that is the disposal receptacles. All right? We brought this up a couple of days ago in the last meeting. What is the situation like now? Mr. Chen, Well, Chairman, in mid-April, we will be meeting all the relevant parties about the arrangement. So you will be meeting with the NGOs in mid-April to discuss the disposable receptacles. Well, we have identified certain locations. Dr. Leung Ka-Lau, let me put it this way. In the new definition of powdered formula, a simple question. Any other relevant circumstances? Now, sometimes you ask the manufacturers for the information, and the information is not included in the labeling. Does it include the information subsequently provided by the suppliers? Any other relevant circumstances here? It does, yes. So the question is, if there is a product which doesn't specify the age bracket, and someone has taken several kilograms across the boundary, you've arrested him, and the labeling doesn't specify the age bracket, and you approach the supplier as to whether they are suitable for children under 36 months. And if the supplier said yes, then this guy would be in breach of the law, wouldn't he? Permanent Secretary. But Chairman, I think well, please answer my question first, and please answer my question precisely that there is a product that doesn't specify the age bracket. Or maybe there is no packaging, and you test, you put the powder formula to a test, and you ask the supplier whether it is meant for 12 to 36 months. If the supplier said yes, then this person would be in violation of the law. Is that right, Permanent Secretary? Well, I have to look at the provision. Now, if there is an unsealed tin of powdered formula, and it doesn't specify that it is meant for those below 36 months, would that be regulated? I'm not sure. I think we have to defer to the DOJ. Mr. Mo, what I can confirm that this can be a factor to be taken into account by the court. Assuming that there are questions put to the manufacturers, and the question may be like who the powder formula is meant for. There is no specification of age bracket. Now this may not be a product meant for infants. Now, I suppose that the court would be of the opinion that it is also meant for 12 to 36 months, and they would fall within the definition. Now, this may be a kind of powder without any specification, but the manufacturer might say that it is meant for pregnant women or adults. There may not be any packaging, but according to the information provided by the manufacturer, the court can form the opinion as to whether this is also meant for those below 36 months. So the way the question is phrased would make a difference. I'm sure that the court would have regard to all this. Dr. Leung. Well, the court will not just rely on the labeling, but also on the information provided by the manufacturers. So I asked you before that you should approach the manufacturers before someone has fallen victim to this regulation. The manufacturer might say that all adult formula may also be suitable for children under the age of 36. So the effectively this regulation would ban all adult formula. Now there are some products that are meant for pregnant women or those above the age of 50. You ask the manufacturer as to whether these products are suitable for children between 12 to 36 months. If you ask them this question, they probably will tell you that it would be okay. Permanent Secretary, let me answer the question like this. When drafting the regulations, we have regard to the problems that we faced and also the nature of the parallel trading in the market. Now, basically what the parallel traders are most interested in are the products that have a specification of certain age. And these are products for that particular age bracket. In the light of this, we focus our attention on this and drafted the regulation accordingly. Dr. Leung raised the question from the medical point of view by saying that adult formula would also be suitable for children. We cannot cast any doubt on this from a medical point of view, but from the legislative intent, now what we try to tackle may not necessarily be the kind of powder formula that would be consumed massively by adults. We cannot say that we disregard the information provided to us by the manufacturer, but we're not sure whether we should ask the manufacturers about all these products. The Customs and Excise has to deal with so many visitors. A lot of them are carrying powdered formula. So you have to balance all these different factors, law enforcement and the targets of law enforcement. And we have to have regard to the labeling of the products, and at least the most suitable way of law enforcement in this regard.
Thank you, Chairman. A lot of people, this regulation has a lot of loose areas or loopholes. The question raised by us, the electrical members, is we all want to tackle the problem, and we are not against the governments. We are just trying to solve the problem. And I really feel for the government officials. As a civil servant, having to defend the government, it's not an easy job. Because now the regulation is very, very loosely constructed. I know it's very difficult, and at the same time you have to defend the administration. I understand this is very difficult. I think, but the point is, I think the intent of the regulation is really far from the original intention. I think it's a problem that you're focusing on parallel trading activities. I think the focus should be on models 1 and 2, because the other models are not the focus for parallel traders. For the existing definition, there's a problem with children under 12 years, 2 years of age. If we limit the definition to products for babies under 12 months of age, it's much easier. So the problem with the regulation now is that the products for people above 37 months of age are also suitable for children under 36 months of age. And babies can also consume adult powder. I think the government has placed a wrong emphasis, and you should limit the regulation to milk powder for children under 1 year of age. And in effect, you are now controlling the trading of milk powder, which is wrong, and this is not the original intent, because our intention should be to ensure babies in Hong Kong have a supply of powdered formula. But you are not achieving this goal now. If you look at the papers, if you set a limit of 2 cans per person, the traders would also overcome it by mobilizing more people. The reason why Macau is more successful is that it's to the point. The government require registration for the babies. We could not get any figures from the inspections. I know your difficulty. If you give us figures which do not support the government's stance, it would put you in a very embarrassing situation. I perfectly understand that. But Chairman, if you really want to ensure the local babies have a supply of milk powder, I suggest we make a survey of how many cans of Model 1 and Number 2 milk powder are there in circulation in Hong Kong. For the rest, we should let them continue with their business and not interfere. This is Mr. Fang's opinion. Thank you, Chairman. With regards to the question on affecting milk powder trade, I want to stress that normal trade of milk powder can still continue. For the manufacturers with an export license, they can continue trading. Regards to the shortage of different models of milk powder, we submitted information to the subcommittee. The milk powder ordered by the government is spread across different models, not just Model 1 and Model 2. I have another question. Would the government consider updating the regulation to cover children from 0 to 12 years old instead of 0 to 36 months? The existing evidence are not enough to support this change. Next question. Chairman, in the last few meetings, we talked about the definition of powdered formula. Just now, Mr. Lau's question on the definition of any other circumstances, it's problematic. If in case tomorrow we have manufacturers who start putting up labels saying that their products are suitable for babies from 0 to 36 months only, in terms of the execution, does it fall under other relevant circumstances? If this has conflict with this definition, what would you do? Chairman, we have to look at the definition of powdered formula. We have to look at the product description. We have to first understand, in general, milk powder products, they have specific target groups. For your question, if the manufacturers put up a label saying that it's suitable for children above 37 months of age, we have to consider whether the label matches the contents itself. The cans also have product descriptions to supplement the target age brackets they're intended for. So we have to make an overall consideration and consider different factors. But if the manufacturers really make this change in the label, and so if as a consumer I want to know which information should I trust. If the descriptions and the labels do not match, what would you do? If the new label overrides the original product description, if perhaps everyone knows the manufacturer had a different intent, I think this is covered under any other circumstances. Basically, we first consider the product description. Every can of product has a particular target age bracket, and the situation you're talking about is if the supplier intentionally changed the label to make it fall outside of the regulation. We would work with the manufacturer to clarify. But if you go and ask the supplier, they would say it's suitable for people about 37 months of age and dodge the regulation. If they're doing business, this is how they would answer. Maybe I'm repeating myself, but I want to say it again. I want to stress that the intended for and suitable for the two phrases are different concepts. They're two different things. Chairman, if they use labels to override the original description, this is part of the product description, the label. We have to consider the new description and whether the intended age bracket is changed. The new sticker might not be the original description. From the description to the information provided, if the manufacturer said it's for people about 36 months of age, we would consider this factor in the execution of the rule. The executing officials can only execute the rule according to their understanding and the regulations. If considering all the factors, the product is intended for people about 36 months of age, that means the product will not be governed by the regulation. Mr. Paul Chair. I want to understand the scope covered. Apart from the suitability and capacity to be consumed, unless some products are completely unsuitable, you cannot cover it in the definition. Thank you, Chairman. I think the milk powder supplier has to bear a legal responsibility in terms of international safety standards. If the contents is appropriate, I want to elaborate, and maybe Dr. Ho can explain more. If the product is not suitable for that age bracket, they cannot say it's intended for those people. We have to look at the product description, because some products are intended for that age group. If the supplier if the product is intended for 0 to 36 months of age, we actually cover all age groups, and in the phrase "intended for" it implies that it's for all age groups. Dr. Ho, any elaboration? If it's intended for, that means it's suitable. Should we clarify the terms? Our intent is very clear. If it's intended for the age group, it's suitable. But if it's suitable, it's not. It might not be the original intention. That's the main difference. The definition now largely depends on marketing needs, and we count on the product labels primarily to see if the product falls under the regulations. But a product suitable for consumption might not be considered in the intended purpose. If the product is intended for 0 to 6 months of age of children, it might still be suitable for those over 6 months. And we have to look at the product labels and the marketing strategies. I agree with my colleagues. Whether it's appropriate or not, in considering this factor, we have to consider the intent. The logic is suitable does not mean intended for, and we can quote a lot of examples to elaborate this point. A lot of children's products are suitable for adults because they contain nutrition, but obviously it's not intended for adults. But we can, as adults, we can consume it. But it's just not the original intention. We have to consider different factors like product description, sales strategy. In terms of the execution, Mr. Mo said it's execution and jurisdiction are separate. But now we have to consider the difficulties in jurisdiction. And thank you, Chairman.
Ms. N. Chung. Chairman, thank you. I go along with Mr. Vincent Fang that after so many meetings, then in every meeting we seem to be putting you in the firing line. I mean, you are having a hard time sitting there. Well, as a matter of fact, there are so many issues that we have to clarify. The purpose of legislating is to make a difference to the situation, but it seems to me that you have or you will create more problems than you solve. So just a moment ago I said, and it was also alluded to by other fellow members, that for someone to purchase some powdered formula, I invite one of you to come with me. Madam Zhang, I've got 5 minutes, Chairman. We are dealing with clause by clause. We've gone past the stage where we talked about policies. If you go round and round in circle like this, it will be not good enough, Ms. Zhang. Well, the soy milk powder, for instance, a lot of infants are using soy milk powder because many Chinese infants cannot consume the other milk powder. Now, what about soy milk powder? Is it subject to restriction? Is it, if it doesn't specify 36 months or whatever, can this be taken out of Hong Kong? When we enact a piece of legislation, I'm not sure whether you've talked with the suppliers. The members of the public may not have a full picture. Councillors do have a lot of problems, and in future it is likely that there can be so many cases of litigation. It would be a hard time for the judges as well. When we legislate, we like to legislate in a proper way. I am anxious for this piece of regulation to go through. Now, we put questions to the officials, and they are shoving the questions to the legal experts. And every time they try to get the law draftsman to fill the questions, the legislators do have the obligation to enact legislation in a clear manner. Right? I'm fully aware of my obligation. The law draftsman has to explain the drafting. The AOs are dealing with the policy. There is a division of work. Chairman, we invited Mr. Mo to answer a question from the drafting point of view. Coming back to Ms. Zhang's question, whether soy milk powder is also within the ambit, it all depends on the labeling on the tin and all the descriptions there. Ms. Zhang? Chairman, there are so many different products. Like cigarettes, you can put a warning label there. Smoking is hazardous to health. Can you have some kind of warning there on the labeling? That we're talking about a fine of $500,000 and 2 years custodial sentence. Can't you make it easier, more user-friendly for the members of the public? Right? Can you formulate some standard for the members of the public? Chairman, we can step up our publicity, but in the market out there, there is a wide variety of powder formula products, and in the light of these regulations, they may reposition themselves. So it would be difficult for us to say to come up with an across-the-board kind of list. Now, we can certainly step up our publicity regarding the scope of the regulation. Mr. Lo Wai-kwok, Chairman, the regulation is targeting at these powdered formula. It has to be unsealed, and there must be labeling on the tin with a description on how to use and so on. So under any other relevant circumstances, can this be deleted? Now, there are so many problems arising out of this that there may be nothing on the tin, but when you seek further information from the supplier, you may be able to get exactly what you want. Now, the officials repeatedly said that it is intended for or claimed to be for consumption. If there is a manufacturer that changes the packaging and it doesn't specify infant and so on, and it is still very much sought after, it is still a product favored by the parallel traders, and I don't think it is likely that this would happen, because without all these claims, the parallel traders will not be interested in them. I think if you do away with any other relevant circumstances, I don't think it would impinge on the effectiveness of law enforcement. Over the past fortnights or so, what is the prosecution by the Customs and Excise like? Has there been a decline in prosecution? Also at the export, can you give us an update? Mr. Chen. Well, we add any other relevant circumstances. Mr. Low is saying that we can do away with this phrase. Now, I must say that the parallel traders always try to outsmart the administration. They are very innovative. They're very creative. Now, if they can black out some of the instructions, like 0 to 36 months. If the Customs Excise is aware that the tin has been tampered with, and if we don't have this phrase, any other relevant circumstances, it would be difficult for us, and it would be difficult for us to pin down whether it is the kind of powder formula that we have in mind. Members don't have to be unduly worried, because in the definition we have added so many qualifiers. They have to be in liquid form, and we have to have regard to the product description and user instructions. Now, if someone has blacked out the 0 to 36 months, or blacked out everything about the instruction, apparently this is the kind of product that we have in mind. So from the law enforcement point of view, we do need to have the latitude so that people cannot circumvent the regulation so easily. Mr. Lin, law enforcement. Chairman, let me bring members up to date. As of 31st of March, 1 month after the coming into effect of the regulation. Now, the Customs and Excise has dealt with 489 cases, 499 arrests were made, 291 Hong Kong residents, 204 mainland and other people, or people of other nationalities. In the first fortnight of the regulation, there were more, about 20 or so cases per day, but in the past 2 weeks or so, the number of cases averaged out to be something like below 20 or 15, 60 cases per day. Overall, the number of cases has declined somewhat. It goes to show that members of the public are aware of the law enforcement, and the members of the public are aware of the regulation, and they're abiding by it. Now, for these 24-hour requirement of the 499 arrested, 1/3 of them contravened the 24-hour requirement. Mr. Vincent Fang. Chairman, I think the administration has got the focus slightly wrong. We should deal with powder formula number 1 and 2 if there are no problems with those 36 months and above, and if the government doesn't amend the regulation, obviously they would change the labeling to say that these products are meant for those above 37 months, and that would take them out of the ambit of this regulation. This powdered formula is not too much sought after by the mums in Hong Kong and the parallel traders. They are really scrambling to buy numbers 1 and 2. Are you going to move any CSA because this definition is too broad in scope? We may have the scarcity. Mr. Fang, I think you're repeating yourself. No, I'm not, Chairman. Chairman, please do not interrupt me, will you? I'm asking whether the government will be narrowing down the CSA. Please do not waste my time, Chairman. Now you have all these different numbers included, 1, 2, 3, 4. Now will you be moving any CSAs to pin down on numbers 1 and 2? And if there is scarcity for certain brands, will you be narrowing down the scope? Because if everybody claims that this is meant for 37 months and above, they would be okay. Well, I'm not sure whether Mr. Vincent Fang was here. I think the question has been answered in no uncertain terms. While I'm asking whether they would be narrowing down the CSA, can you go back to the record? You might wish to go back to the audio record. Did anybody raise any suggestion that the CSA be narrowed down? Well, I think you have to go back to the record. Well, we can go back to the audio record, Chairman. Well, if I am wrong, I will apologize to you. If you are wrong, I hope that you will apologize to me. Permanent Secretary, I'm inviting this Permanent Secretary to answer the question. Chairman, as to the numbers that are sought after by the market, I defer to Mr. Philip Chen. Chairman, we did make available the information. There are orders placed through the hotline as of the 25th of March. I think I can name them. One is Frizzle, the other one is Mead Johnson. Mostly they place order for age 1 to 3. Mead Johnson 2,279, 909 are for 1 to 3 years of age. Well, you talked about 1 to 3 years, 1 to 3 years old. Yeah, 1 to 3 years old. That's numbers 1 to 4. Is that right? Well, Chairman, Mr. Fang asked the question as to whether we can narrow it down to 0 to 12 months. Now, what I'm saying is that through the hotline figures, we see that 1 to 3 years old, the orders are the highest. Did they mention the particular numbers, or did they just mention 36 months or what? Well, from the suppliers, we have verified the figures. 0 to 6, 6 to 12 months. We have all these different brackets. Mead Johnson, 0 to 6 months, 746, 6 to 12, 501, but 1 to 3 years old, the number is the highest, 909. Frizzle, 0 to 6 months, 74. Number 2, 6 to 12 months, 52. But 1 to 3 years, 500. 39. So it is the bracket 1 to 3 years of age, and that is the most sought after in the orders.
會2881縮12-13歷1號文件，裏邊係每一個品牌每一個號，你所講嘅1、2、3、4號係好清楚喺處。下一位，謝偉俊議員。
主席，首先我先再重溫翻剛才問個問題咧，關於嗰個任何其他嗰度咧，我想理解下呢個胡專員比我會更加熟悉啦。我哋係有幾多類型嘅法例咧，會用呢種所謂 any other circumstance？
How many? When will we adopt this definition of any other circumstances? We cannot provide a concrete number now. It might not be not every situation is covered under any other circumstances. But we have a lot of clauses, and some of them with legal effects. A lot of clauses have considered this situation, and this is a common situation, not a specific case. Let me narrow down my question. From your experience, and I know your experience, how many cases how many cases of violations were executed depending on third-party information afterwards? I might have to invite Mr. Mo. He will be more experienced in legal matters. In terms of other third-party information, in certain situations, in some cases it will be covered under any other relevant information. I'm not able to provide any figures at this moment, but when we talk about the overall situation, in general, it covers other information such as product description and instructions. That's why we need to include the phrase any other relevant situations. And these relevant situations usually do not cover specific things, but covers a number of other situations. It might not just apply to the product description. There are cases when suppliers change their labels, and in some cases they could change they should switch the product, the milk powder, to a different container, and therefore information provided afterwards might be considered a specific case of any other relevant circumstances in terms of the law enforcement to the jurisdiction. These are information which might be considered by the courts. If to put it more specifically, I think any other circumstances would cover information provided by third parties. Thank you, Mr. Mo. You are more experienced than me, but according to my understanding, if the legal effects are steep, we have to narrow down and really refine the phrasing. But if the government's intention was to counter such activities, do we have to use such specific terms? Ms. Chang? You talk about the phrasing. Can I follow up on the question on the Customs Department? As of the 31st of March, we had 499 arrests, and as of 31st of March, are you talking about? So you are talking about from 1st to 31st of March, and you said 1/3 of them contravened the 24-hour rule of not bringing more than 2 cans of milk powder. It applies to people who have left Hong Kong within the past 24 hours. And what about the other 2/3? What did they violate? The rest violated the amount of milk powder, which is 1.8 kilograms. The milk powder we confiscated, in most cases, they have very clear labels. What about the people's explanation? The people arrested did not have specific explanations. Chairman, I receive reports from the locals that they are not clear about the definition about the rule. Will we clarify the regulation with local residents? Do you know that it's a trend to give milk powder as a gift, as souvenir? In the past, we used to give cakes or other foods, but now it's the trend to give milk powder as a gift, milk powder for all ages, and to give milk powder to mainland visitors is a trend. But right now they are not clear what kind of milk powder they can bring and which they cannot. Can you explain your promotional strategies at the points of at the ports? Can we, after this meeting, can we go to the pharmacy together? Because they have salespeople who can explain to us. How would you make your choice? Would you examine the usage instructions? Would you examine each can? The scope is very unclear. If we have a law, we want to make it clear so that the general public has no misunderstandings. If the government should solve the problem through administrative measures, and if we have a law here, we have to make it clear for the general public. Thank you for your question. Under this definition, we know that it's just an amendment, we have strived to make it as clear as possible under the law. But you mentioned why we didn't use administrative measures to solve this problem. We actually considered a lot of solutions. We met suppliers. We looked at the supply chain. It's a commercial activity and the government cannot intervene much. The only solution we have now is to use legislative means to control the use of milk powder. In terms of the consumer level, I think the consumers need to examine the milk powder themselves, and even without the legal considerations, they should make their own judgments. If the target age brackets are not children under 36 months of age, an obvious example would be a pregnant woman who has, or women who had given birth, or products intended for elderly people. This would not be under regulation. Chairman, we put focus on the promotion. We promote them through radio stations, TV stations, posters, pamphlets, and we also put up banners at the points of entry. Right now, the general public is getting to understand the legislation better. When they buy milk powder, they would make their purchases at pharmacies or supermarkets according to their needs. They know when they make the purchases, the prices are different. And in our promotions, we aim to clarify the legislation to the public. Next, Mr. Leung, to follow up on my last question, under other relevant circumstances, you said in cases of disputes, even if the label does not state that it's for people from 12 to 36 months, but they provided supplementary information to support that they have violated the rule. And the secretary made a point that it's very hard for us to consult the supplier for every single case, and we rely mainly on the label. If my understanding is correct, in terms of the flexibility of the legislation, if I'm correct, this new definition, if we enforce the law strictly, anyone, you have the right to arrest everyone who brings over 1.8 kilograms of milk powder, but you would not enforce that. The laws are very strict, but when you said when you enforce the rule, you would mainly rely on the label. Our law enforcement has to be clear for frontline staff, and the guidelines have to be very clear. When we draft the rules, we have to consider the product description and instructions, etc. And this, for stakeholders, we make things clear for all the stakeholders. My question is, is my understanding correct? With the law laid out this way, is the government, is the customs entitled to arrest everyone. I can only say that we can follow the rule.
我有一點我想補。
Chairman, if I may add, I still have a bit of time. The Permanent Secretary mentioned the figures, the hotline figures, 1 to 3 years of age. This is a product that is the most sought after. For those under 1, the 2 products. 1,200 orders placed, 2 to 3, 450. So on the basis of the hotline figures, those below 1, the demand would be greater than those between 2 and 3 years old. Mr. Raymond Chen, Chairman, I support this legislation. I'm not trying to make life difficult for the officials. We've been debating this for so long. It would be very difficult for us to have a watertight piece of regulation that would not catch any innocent person. I'd like to ask a logical question, which is similar to Dr. Leung's. If on the tin it doesn't specify any particular age bracket, logically, it should be 0 to 100 or 0 to infinity. Last time, Mr. Sly, the Permanent Secretary, said that if on the tin, if in the product description or user instruction it doesn't mention any age bracket, then it would not fall within the ambit of this regulation. Will Mrs. Lai tell us again, logically, just because it doesn't say anything, it would not fall within the ambit? Mrs. Lai. Yes, correct. Now here we have regard to the product descriptions and user's instructions and any other relevant circumstances. The substance is intended for or claimed to be for consumption by persons of any age under 36 months. Now if on the tin the packaging doesn't specify intended for or claimed to be for any particular people, it doesn't fall within the ambit. Mr. Chen, when we mention any other relevant circumstances, if the tin doesn't contain anything at all, then it would fall outside the regulation. But if someone carried the powder formula loosely in a container, then you would ask the manufacturers, and one is likely to be on the wrong side of the law. It all depends on how or what response is given by the manufacturer. Is it correct, Mrs. Lai? But if the tin is an unsealed tin and the labeling is untampered with, then what I said would apply. But as Mr. Philip Chen said a moment ago, there may be certain circumstances that in which someone has tampered with the tin. They've blackened out, or they've covered up certain phrases and so on. And then because of this tampering on the tin, such that there are no phrases intended for or claimed to be for, then it would cause suspicion on the part of the frontline staff, and they would reasonably ask whether the tin has been tampered with with a view to covering up certain things. Mr. Chen, are there many tins that don't contain or carry any age bracket? Any powder formula out there in the market that don't carry any description about an age bracket? Not many, I do think, Chairman, but I defer to Dr. Ho. Dr. Ho? In the market out there, there are certain powdered formula that doesn't specify any particular age bracket. Mrs. Lai, if someone carries this kind of powdered formula across the boundary, will he be prosecuted? Well, I have to be consistent with what I said. If the container, if the tin is silent on any phrases intended for or claimed to be for persons of any age under 36 months, it would be outside the ambit, unless the tin has been tampered with to cover up certain descriptions. In that scenario, it may give rise to suspicion. If we're dealing with unsealed tins, if the manufacturer produces something that doesn't specify the age bracket, then it would be outside this ambit. Yes. All right, any follow-up? Mr. Tommy Cheung for the first time. Chairman, I heard what Mrs. Lai said. I've got other questions, but I'd like to pick up on the reply. If the manufacturer doesn't say anything on the tin, then it should be fine. But if it says from 0 to 1,000 months, and it would be caught. If the tin has been tampered with, the labeling has been tampered with, something obliterated, something covered up, and so on, this would be wrong. But if the powder has been put in a gunny sack for to carry with someone, then I mean, if the powder formula has been put into a sack and carry these across the boundary, it would not be caught, would it? Mrs. Lai, it would be hard for me to talk about individual isolated cases. Well, this is not isolated case, Mrs. Lai. Let's say I've got a tin, I got rid of the tin, I know what the content is, and I've put the powder in different containers. I've 10 tins, I pour all the content into a plastic bag, and I take it across the boundary, and once I cross the boundary, I put it back into the tins. Now here you said that if the powder is in a big plastic bag, 10 tins are worth of powder in a plastic bag, I wouldn't be against the law, would I? I mean, if I tell you that I do this every single day, will I be on the wrong side of the law? Can you say categorically? Mrs. Lai. Chairman, when the law enforcement officer looks at a particular case, he will look at a whole basket of factors. What I said in reply was that if the labeling on the tin is completely silent on any phrases like intended for or claimed to be for persons of any age under 36 months. Well, Mrs. Lai, I don't want to queue up again for the second round. I mean, you seem to be taking me round and round in circle. I've done enough of that. Simple question. I've bought a tin of powdered formula. I've poured the content into a plastic bag, and I take it across the boundary. And I should be all right, shouldn't I? This is the precise question I put to you. Never mind the tin, never mind the law enforcement officers. That the content of the tin has been poured into the plastic bag, no labeling. Will I be all right? Mrs. Lai. Mr. Chen. Well, the Customs and Excise did answer this, and there are problems with this practice. First of all, the Customs and Excise would suspect that this would be white powder, meaning drug. Well, I allow you time. Doesn't matter, I can queue up again. I've got plenty of time. Well, second, we would ask the visitor what this is all about. If we were to say that this is a powdered formula, then even if in absence of product description, we're not really regulating on the basis of the tin. If there is labeling, if there is the tin, then we can use it. But we can use the any other relevant circumstances that this is powdered formula, and by his own admission, this is powdered formula. Well, I think you have to refer this to the legal expert. Nobody is saying that I cannot take any powder formula across the boundary as long as this is not meant for those between 0 and 36 months. You cannot tell me that as long as this is a powder formula, I would be in trouble. You said that if there is no labeling, if it doesn't say that it is meant for 0 to 1,000 years old, it would be all right as long as it doesn't specify that it is for 0 to 36 months. We've got the legal advisor who's been sitting there for so long. I think what you're saying is getting really confusing. Well, Chairman, previously I got a question that I'd like to follow up. Mrs. Sly keeps saying that the customs and excise might give you trouble. Now, this is not the trouble. You can come and give me trouble every single day. But the question is whether you're going to have any chance of successful prosecution. Now, someone is carrying a big plastic bag of powdered formula without any labeling. You ask me who this is meant for. I said, I don't know. I use this for my mum, and there is no labeling. And you cannot prove that I try to circumvent the law. Can you really prosecute me successfully? Mrs. Sly or who else? Chairman, if from my understanding of Mr. Chung, he's talking about some packaging, repackaged, right, with a plastic bag. A plastic bag without any labeling. He got rid of the original packaging and put the content into an unlabeled container. Chairman, on one occasion you talked about a tin of powder formula. As long as it doesn't specify 0 to 36 months, it would be outside the ambit. It is not against the law to take it across the boundary. You can bring as many as you desire. My second question is, if I carry the powder formula in a plastic bag, again, no labeling, is it also in contravention of the law? Third, now you said that you may raise some suspicion. I mean, you can make life difficult for me, fine. Law enforcement agencies can construe that as drug. I mean, any powder can be construed as a drug, and the pills can be construed as a ketamine, fine. But when it comes to prosecution, can you really successfully prosecute me? This is my question. Mrs. Sly. Well, at this point in time, it would be hard for me to give you a categorical answer because it all depends on the circumstances and also the dialogue between the traveller and the customs and excise officer. Well, perhaps Mr. Lin can help. Or Mr. Mo. Well, I don't claim to have a lot of expertise here. Now let me try to help with the discussion from this angle. Now we are discussing the product descriptions and users' instructions. All of these are intended to establish the intention, i.e. intended for or claimed to be for. Now Mr. Chung cited some examples. There is a tin that doesn't specify the age bracket. The permanent secretary has got it right in her answer, but when you talk about the powdered formula that is put in a plastic bag, now there is no description, and then they would look at any other relevant circumstances, and they would have regard to the information derived in the investigation, and that would come under any other relevant circumstances, and that would enable them to establish the intention of the product, whether they intended for that particular target group.
Next, please. with regards to the relevant circumstances, I just checked it in the system. In the Hong Kong laws, the words relevant circumstances appear 50 times. But in most cases, it's used to determine legislation fees. I think it's very rare. Using this phrase is very rare because it would lead to a lot of questions. One more thing. If we look at the company ordinance number 57, section J2, it says a person shall not be guilty of the offense if he does not know the relevant circumstances. And this is the general principle. If a person is legally liable, but he is not aware of the relevant circumstances at that time, according to the law, he would not be guilty. If anyone can prove that he's not aware of the relevant circumstances under the time, he would not be held legally liable. But now, what you're talking about is different. You said even if I wasn't aware of the circumstances, you can still go to the supplier later and ask them. If you look at the company ordinance again, and it's very common in the law, if the person is not aware of the situation at that time, he should not be legally liable. Mrs. Lai, would you answer this question? I will try to answer this and ask Mr. Mo to supplement. In our discussions, this time, in this meeting or previous meetings, it emphasized the importance of having including any other circumstances to handle certain unclear cases. Some LegCo members talked about putting the milk powder in plastic bags. From our understanding, parallel trading has its own demand. More specifically, it's a demand for high-quality products, and in most cases, these products are sealed and untainted. But in the future, we wouldn't know if parallel trading activities will extend to other cases. That's why we need the phrasing, any other circumstances, to give ourselves leeway. Please exit the room if you need a private discussion. We need room for law enforcement, but we will make sure that all the evidence quoted must be reasonable and according to legal considerations. And when we bring a case to courts, they have to meet all the requirements. So that, as a result, we would not have excessively big room for discussion. Would Mr. Wong have any elaboration? Thank you, Chairman. Regarding the question of some people placing milk powder in a plastic bag without labels, when we look at the actual enforcement, to be frank, for a frontline worker at the customs, he might not be able to gather all the intelligence. When we talk about any other circumstances, we can imagine in different cases. When we talk about parallel trading activities, the customs enforcement task also covers collecting intelligence or monitoring. Assuming the customs staff sees a plastic bag without labels, in actual circumstances, if we can spot out such activities through our inspections, if we spot anyone putting milk powder under monitoring into plastic bags, the regulation would help us carry out the law. You didn't answer my question. I was talking about people who were unaware of any other circumstances when they carried the milk powder, and they were not aware that they broke the rules. Just now, we talked about original untempered milk powder. These would not fall under the regulation, and the people won't violate the rules. We have to look at a host of reasons. If the container does not contain any information on the targeted age bracket, they would not be if the customs have any doubts, the customs would call up the supplier, and if the supplier said there's no age brackets, then they would have violated the law. So if I bring the original can, I wouldn't violate the rule. But if I put it into a different container, and if you consult the supplier afterwards, and the supplier said it's for 0 to 100 years old, then the person who put the milk powder into the plastic bags will be prosecuted, and that's the problem with the logic here. Going back to the information you collect, the information you collect should be to confirm whether the milk powder is intended for the particular target audience. The targeted age brackets are in effect the same as using the original package. Consulting the supplier is just to confirm the facts. Mrs. Lai just said your target for countering parallel importers are sealed cans, unopened cans. Since if people put it into another bag, it's hard for them to resell it. And that's why I don't think you need to state any other circumstances. As I said, parallel trading activities change all the time in terms of its mode, its methodology. At the moment, only unopened cans applies, but we cannot rule out the fact in the future that once we have the legislation in place, parallel trading activities can transform into other forms. If we don't have this any other circumstances, we don't have this phrase. If we eliminate this phrase and depend on product description only, let me give you an example. If I'm a parallel trader, I would buy a can of baby milk powder, and I would record the process of opening the can and transferring to another bag, and I would still be able to sell it to customers, because the customer would believe that the powder I sell comes from the original can. So if we don't have this phrase, any other circumstances, this would lead to a lot of people trying to dodge the regulation, as long as they don't have an explicit description. I think the law would lose its effect in this case. Mr. Chang. Chairman, if the original intent is to counter parallel imports, I have another view. Everyone knows milk powder is not in shortage, essentially. The new fathers could buy the cheapest powder. If I'm a user, I can buy 10 cans and bring it home. If the intent of the rule is to counter parallel importers instead of personal use, you don't have to worry about what the parallel traders can think up in the future. You have to make it clear that you're only targeting milk powder products for babies from 12 to 36 months old, and instead of all milk powder. If you put the milk powder into plastic bags, you should not make any prosecutions on this ground. I think there's no need at all. I think, Chairman, you don't have to ask her to answer the question again. The Liberal Party thinks this is a very loosely assembled law. It's very hastily put together, and we would not support it. I think the more your colleagues explain it, the more confusing it becomes. I do not want to repeat myself because they are dodging the question. Mrs. Lies was dodging the question all the time. Chairman, I think the discussion is mainly around the way the phrasing in the legislation is that it covers too much. Well, at the first place, parallel trading is not illegal. I understand now we are changing the legislation to safeguard the rights of local parents, but if the way you phrase the legislation, such as any other circumstances, it would lead to huge flexibility and a very wide leeway for law enforcement. if you cover everything, I think we don't have to act to such a great extent. Just now, last time I asked if I open a can of milk powder and put it in another sealed container, it already lost its the value of parallel importing. And if we buy milk powder as presents, these used to be legal activities. Do we have to act to such a great extent? Where's the line?
Well, if we do away with the phrase any other relevant circumstances, even if in the absence of that, we can still tackle organized parallel trading activities. Now, there may be some individual who purchase the powder formula for their relatives or for their grandsons and so on across the boundary. And there may be some people who transfer the powder formula into separate containers. Should this be relaxed? Should we restrict all the powder formula to Hong Kong babies to the exclusion of everybody else? Hong Kong is a free market. Now, this is basically a kind of lawful activity. I don't know how soon this piece of regulation will lapse. 1 year, 2 years, or what? I mean, do we keep this until such time as people in the mainland are confident in their own powdered formula? Now, you are making it so strict, and this is not the general sentiment that you're reflecting. Perhaps we can accept the effort to tackle the parallel traders who are dealing with certain brands if people are buying certain tins for their relatives, if people are transferring the powder formula into separate containers, then you can relax it a little bit. You don't really need any other relevant circumstances. Mrs. Lai. Chairman, we did deal with similar questions before. Let me say this simply again. Now, the duration for which the regulation will be effective for, we will keep this under review. We have to put the supply chain into to some kind of stress test, and it is only that they pass the test that we will consider removing this regulation. I mean, we've said this even in absence of any specific sunset clauses. As Mr. Sin said, if we draft the regulation in such a way as to merely tackling parallel trading activities, there would be difficulties because there may be syndicates behind the parallel trading, but they are doing it in small quantities. Are they individuals or are they a part of the syndicate? And it would be exceedingly difficult for the frontline staff to institute prosecution. For a piece of legislation to be effective, we do need to have a piece of legislation like this. We have achieved tangible results. After the 1st of March, there are still parallel traders. doing the business, and it goes to show that there is a need for this piece of legislation. Now, Mr. Sin said that the legislation is watertight. Now, the other side of the coin is some members criticized this piece of regulation for being too sketchy. Now, are we causing any trouble to the members of the public? Now, we don't really want to have any legislation to have any bearing on the day-to-day life of the members of the public. That's why we have the exemption, like the 1.8 kilogram 24-hour requirement, exemption if babies are accompanied by adults or people over the age of 16. Also, if a certain product is not meant for this particular age group, they would be exempted. So we'd like to strike a balance. On the one hand, we'd like to combat parallel trading activities. On the other hand, we'd like to make sure that people's daily life will not be affected. Right? We're here till noon. It is 11:35 now. I'll draw a line after the members have spoken. Mr. Lo-Wai-Kwok, Chairman. A couple of members did raise doubts about the phrase "any other relevant circumstances." Mr. Dennis Kwok is a lawyer, and I am an engineer myself. As an engineer, I do share Mr. Dennis Kwok's comment. We have to be very clear in our definition. I've never seen any definition that contains any other relevant circumstances. Now, some members said that the regulation is sketchy. Some said it is watertight. Now, the thing is that we shouldn't go that far. Now, we should count the definition in narrow terms to target at specific people. Now, in absence of this phrase, what difficulty will be presented to the Customs and Excise in their law enforcement? Now, the scenario depicted by Mr. Sin, I don't think we need to tackle this. If someone has transferred the content into separate containers, and if there is a market for that, then it would be a different story. If there is such a scarcity that they would also go for this kind of product, and then that would be another story altogether. I don't think we should be going that far in our definition. Here, in the amendment, in the original definition, there is a phrase "appears to be," and this will catch a lot of people unnecessarily. This amendment is desirable, but I don't think we should have this phrase "any other relevant circumstances." So I hope that the administration would have regard to the chorus of opposition from members today. Now we have the Deputy Director General. I hope that he would answer me in relation to the export figures. Right, as of 5th of April, from 1st of March, the TID issued 930 odd export licenses involving a quantity of 1.5 million tons of powdered formula, more or less than before. Well, Chairman, we didn't have the requirement of these export licenses before, so it would be difficult for us to make direct comparison. Well, you said that the export license can be issued within 2 days. Yes, indeed, all the export licenses were approved and issued within the time frame specified. Mr. Vincent Fang. Chairman, what is regrettable is that the TID didn't have the previous figures for comparison. I think one can imagine that there are more cases of transshipment. Many people have gravitated to Macau, And instead of coming to Hong Kong, they've moved to Macau. Now, if I may put this to the Customs and Excise, with the introduction of this regulation, if someone carries 2 tins of powder formula or less, do you require any declaration? Mr. Lin. Chairman, thank you. If a visitor carries 1.8 kilograms or less worth of powder formula, there is no need for declaration. But in our course of work, we are enforcing the relevant legislation, and there is an exemption requirement that this 24-hour requirement that we will conduct random checking to see whether anyone has contravened this requirement. Mr. Fang. Now, with this restriction order, there may be more parallel traders being deployed. If this is the case, then it would negate the effect of this restriction order. Now, we are concerned about H7N9. We are concerned that they may be bringing with them this virus to Hong Kong. Now, as was said a moment ago, if there is no labeling on the tin, there can be exemption. And if on the tin, previously there was no such description, but with this restriction order in place, if the supplier were to specify on the tin that it is meant for people above the age of 37 months, then it would fall outside the restriction order. Is it correct? Mrs. Lai, I think this has been answered many times. Chairman, I think we have to look at all the descriptions and the labeling on the tin to see whether they are consistent and specific enough. Well, they have to be consistent and consistent. Now, with the powder formula, I think Dr. Ho has answered that a moment ago. Now, these powder formula can be used by people above the age of 13 months. But the government is so stubborn as to not being willing to move any CSAs. Now, babies above 13 months, they can consume these powder formula. If the government has to move in this direction, the suppliers, they can't argue with the administration. The suppliers can specify on the tin that the product is meant for anybody above the age of 37 months. Would they fall outside the ambit of this restriction order? Mrs. Lai, if all the labels and descriptions are consistently saying that they are intended for or claimed to be for consumption by persons above 37 months, then they would fall outside the ambit. Mr. Porche. Chairman, before Mr. Dennis Kwok took the floor to speak, I also conducted some quick research. I think this is comprehensive enough. Now, this phrase, any other relevant circumstances, in the laws of Hong Kong, in the ordinances, there are 692 entries, 460 entries in the subsidiary legislation, about 1,000 entries in all these laws and subsidiary legislation. But in the majority of the cases, unlike Mr. Kwok said, they don't appear in the definition or in the interpretation. It's only when the court of law decides whether someone is guilty that this phrase would be looked at. Now, Mr. Mo, you said you don't have any expertise on prosecution, but I'm sure that I can say that I've got more experience than you in this regard, but we are very concerned about this kind of phrase because this would make things wholly unclear. The Permanent Secretary made the point which made me even more worried. She said she would have regard to the law enforcement and the dialogues between the law enforcement officer and the visitor. And the general public may not have the full picture. I think the law has to be clear-cut. It should not be dependent on how the dialogues pan out to decide whether someone is guilty or not. What is even more worrying is that if the tin doesn't contain any description, then it should fall outside the ambit. But this is not what the law should be interpreted. If the supplier were to claim that the powdered formula is intended for not just those above 36 months, but also those below, then in theory, someone would be caught by the dragnet. The law should not allow this situation to arise. In particular, if you want to enact legislation, and we're party to this enactment of legislation, we cannot allow this situation to occur. So perhaps I don't think we can complete this today. Perhaps the law draftsman might wish to make available the information that I didn't get hold of in the definition. Any pieces of legislation that contain any other relevant circumstances in the definition or interpretation, please let us have the information. And also for other products in the import and export regulation, I don't think there is such an ambiguous definition. In this regulation, is there any product, any provision that wouldn't have this phrase in the definition, please?
I will make a detailed explanation. I'm not placing a restriction on the definition. It's we had a lot of previous past cases. From what I have in hand, for example, showcasing banners which promote indecent behavior, and how we can interpret this this law can be found in the number 147A. It depends on the place of showing or any other cases. And this is very similar when we consider an ordinance in crime. We would consider other circumstances, and this is very commonplace. It's we under the ordinances we have to cover different circumstances or factors. The legal advisor has some questions, so I will reserve some time. Thank you, Chairman. I want to say three things. The first point, Mr. Kwok said the present definition does not lead to a clear, reasonable understanding. We wrote to the government a long time ago on the topic of strict liability offense. We asked whether it contains includes common law defense, and I will quote the government's reply. They admit this is a strict liability offense, but this is not an absolute offense. But it's not directly ruling on Section 63 itself. So this is the government confirmed that there is a common law defense. For the government's new revision, you have had a very wide discussion, but the government has not explained to us when this revision will come in force. Will it be backdated to the 1st of March? Or would it be in force on another date? I think this is something the government has to explain. If it's backdated to the 1st of March, the definition has changed compared with the previous one. And some of the present enforcement activities might be affected. If the law would be enforced later, the government will have to explain. This has not been discussed before. The third point, I have to go through very quickly. The definition of any other relevant circumstances. Some of you are very concerned. If we look at the present policy, the most important thing of the definition is the product is intended for or claimed to be for consumption. Claimed refers to the depends on the product description and instructions, but intended for means that with a lack of product description, in cases where the container has already been opened, the claim would become problematic. If the product does not have a description or it's not in whole package, you have to look at the intention. The intention at the point of manufacturing. What kind of people is the product intended? Are they intended for? If you look at the definition, with regards to the problem with the product description, if applicable. So if it's not applicable, how can we prove that the product is intended for the target group? If we take out all these phrases on product descriptions, if we are only left with the phrase that the product is intended or claimed to be for consumption, when the case is brought to the courts, we must consider the relevant circumstances. So we cannot remove such phrase. I would like to exercise the chairman's right to extend the meeting by 50 minutes. Thank you, Chairman. Some electrical members said if you only that you can only you only need the phrase any regard to any product descriptions. So if the product does not have descriptions or instructions, it's not applicable anymore. So I think the effects will be very grave. Some of you might be unclear about the chairman's elaboration. I suggest Mr. Mo to supplement more. In my opinion, the government needs to explain by writing this definition and the scope of this definition. I think the government needs to explain this to us, the subcommittee members. Mr. Paul Chair's opinion is very important. I think it's not possible for us to have another meeting The opinion of the electrical members, their intent, these relevant information is crucial. Our deadline is the 10th of April. As a lawmaker, we need to have clear legislation, and we cannot just look at the timeline, and we cannot make the law ambiguous. We should not be constrained by time. Even if you give us survey results, we have an obligation to ask this question. I agree with you. If you feel you have an obligation, you should come at 9 a.m. this morning. I listened to what you said in a room this morning. Please give me an answer why we cannot have another meeting. I want you to take back what you just said. And secondly, I want you to explain why we cannot have another meeting, so that all of us can clearly understand the law. So please don't give any personal attack. You should explain clearly why we cannot have another meeting, or why we have time constraints, if you support the government on this. But as a electrical member, I cannot do this. We have already extended the dates of the legislation to the 17th of April. So the latest, we have a latest amendment date. We can have a meeting tomorrow or 2 days later, or at 10 a.m. We should not be constrained by the government's time frame. We are not robots. We should do our job. If you have a suggestion when to have a meeting, Chairman, it's not about my opinion. We have particular procedures, and it's not just up to what you or me or I think. And apart from those present, a lot of we have to listen to opinion from those electoral members who are absent today. What you just said was different from what you said earlier. You do not have an absolute right as chairman. I can only have the right to extend the meeting by 15 minutes. We cannot have another meeting due to time constraints. We can make time for further meetings. We will accommodate. Last time I suggested to have another meeting, but I was rejected by the electoral members. Can you see if everyone agrees to having another meeting? Today we have 10 people. But this subcommittee has 26 people, so 16 were absent. So the present members now cannot represent those absent. The most important thing is for people who want to ask questions. those who are not here feel satisfied already. If we have a meeting and we do not meet the quorum, it's the LegCo members' obligation. We're asking some solid questions. Chairman, if we as LegCo members have a lot of questions, but yet we have time constraints, what should we do? Is the 17th of April an absolute deadline? If you have a lot of questions, there are a few ways. You can make amendments, or you can express your views, whether you agree or not. But during this discussion, as chairman, I gave all of you ample time for questions. But if I sense a lot of repetitions as a chairman, I have an obligation to explain to all of you that's to not circle around the same question. We are not going circles. On the 8th of April, Monday, 8:30 a.m., does anyone have a problem? We have to ask the administration. We have no time whatsoever. Our deadline is the 17th of April. We have to present. If we cannot solve the problem on the 8th of April, we will look at the 9th or 10th. You should ask the government officials. Personally, I'm not free on the 8th, but I can make it on the 9th. I'm just concerned you wouldn't meet the quorum, and if we do it on the 9th, we can also give the government officials more time to prepare. So we can still meet the date for amendments on the 10th of April. What about 10:45 a.m.? On any questions, any problems? Monday, 8:30 a.m. Mr. Mo, any question? If we will meet at 8:30 a.m., we will do our best over this weekend. Do we have a vice chairman for the Company Ordinance Committee? How about Mr. Chair and Mr. Kwok? Can you attend both meetings? So let's make it 10:45 a.m. on the 9th, Tuesday. during the next meeting, I hope the amendments would be completed. Thank you, everyone.